we're going to get into it. So, thank you everyone for joining. Today we're going to be talking about managing regulatory risk, which is a big part of your climate-related financial risk reports, and the work that many of you are going to need to be doing. So, this is a little bit of what the agenda is going to look like today. So, I'll give a quick introduction as to who we are, why we're talking about this. We'll talk a little bit about what is expected of companies from a climate from reporting on climate-related financial risk. We'll share a few examples of how other companies report on this. I will talk a little bit about how Beehive helps and just give an example of this cool new feature we built related to regulatory risk. And then we got Nico Van Alstine, who is a partner at law firm Shepherd Mullen, and we're going to do a little interview with him. So we've got the chat open, we've got the Q&A open. Let's make this interactive. Reach out and say hello at any time with a question, a thought, a comment, how you guys at your companies are handling climate risk. You could feed a question in that you want to make sure we ask Nico, the lawyer, to make sure I get to that. So let's get going. So very quickly, who we are. So my name is Adriel. I am the founder of a company called Beehive. And Beehive, we help our clients with climate-related financial risk reporting. So if you have to comply with CSRD or California's SB 261 or any of these 30-ish global regulations requiring climate-related financial risk, or you want to manage this risk at your companies, our software helps you do that. So let's talk specifically about regulatory risk. So I'm going to just set the stage a little bit, and then much of the conversation will be an interview with Nico. But there's a few places in which regulatory risk really comes up in these climate risk reports, TCFD or IFRS S2, that you are going to be reporting on. So very specifically, this is from the TCFD guidance upon which the IFRS S2 guidance is based. We see there's a whole section called policy and legal as what's called a transition risk. And just for some context, you want to be reporting on your physical risk, which is what happens if a wildfire or a flood or a storm hits your community. And then you also want to be reporting on transition risk, which what is the impact of a changing world and changing climate in a non-weather sense around you. So how does your reputation might be impacted, the market around you might change, new technologies might be developed, or our topic of conversation today, how policy and legal changes around the world might impact your business. So there's give a few examples here that you might want to talk about. How new regulations could cause an increased pricing of GHG emissions, how there might be more regulations around the world requiring emissions reporting obligations. There might be different mandates, and you might be exposed to litigation. And there's some interesting ones here. So for example, just to touch upon emissions reporting obligations, there's a little more nuance than you might expect. So many of you know that laws like California's SB 253 require businesses with over $1 billion in revenue to report your carbon emissions. CSRD in the EU has a similar carbon emissions disclosure requirement. And over the years, that actually drops to a fairly low revenue marker. I think actually the lowest in a few years, if you are based in the EU, it's a company with over 50 million in revenue that might be required to do this stuff. And then there's even more nuance. So for example, in the Netherlands, there's a law that says any Dutch company, and this includes an American company with a Dutch subsidiary that has over 100 employees and some other low marker, has to report on carbon emissions from business travel and employee commute. So there's like, you think you know the big ones, but then things like this Dutch law come around, or UK law that says if you use X number of megawatt hours a year, this has been existing since 2019. If you use X amount of energy, then you need to be reporting on your emissions related to your buildings as well. So there's all these different laws around the world, and they impact you in different ways depending on who you are. There's an interesting caveat to how you want to be reporting on this, and that's specifically about quantifying this risk. And so this is from the IFRS guidance that CSRD is based on, for example, and they talk a lot about disclosing the quantitative and qualitative information about how this is impacting you. So there's a few things to point out here, but from this guidance, they talk about how you want to be providing either a single amount or a range, and how you should use this reasonable and supportable information available to do this work. And they do talk about without undue cost or effort. So there's a little bit of flexibility in there, but you really want to define how much risk you have from policy and regulatory changes. And somewhere in here, let's see if I can find the exact line. Whoops, we lost it there, but it's somewhere. Here we go. I think here. So they talk about how you want to talk about your quantitative risk if you have higher risk, and the lower riskier is, the less value there's to quantifying it. If you say you're a billion-dollar business and you say, I have exactly $37 worth of risk, congrats, you quantified it. Nobody really cares. If you are a billion-dollar business and you say, I have within 300 and $500 million worth of risk, well, that range is a really big range, and you really need to be a lot more narrow there. So I think this slightly depends on materiality, but basically, you want to be quantifying this work. And in regulatory risk, one easy way to do that is by quantifying the fines associated with noncompliance. But this is an evolving area. The first CSRD reports just came out. There have been a few thousand TCFD reports, and they've changed over the years, but we'll just take a look at a few of them to give you examples of how your peers are reporting on this. So my first example here, and I'll zoom in so it's a little easier to read. Whoa, zoomed in too far. It's from Atlassian. So you see under their transition risks, they have a whole section about regulatory risks that might come up. And they say in the short term, climate regulations may add costs. Now they're a little general. They don't quantify, they don't even give a range. This is from, I think, a year or two ago, but they mention it. You take another company, this is CarMax, and they give you a little more context. They define the risk of policy and legal. So they talk about environmental regulations and enhanced climate reporting requirements and carbon prices. They talk about the impact that this might have from a financial perspective, and they talk about their mitigation strategy. So they give you a little bit more context. Another example is HubSpot. I think one reason I find HubSpot fairly interesting is because where they report on it, they actually have two examples of policy and legal risk that they talk about. One, which I haven't seen in many other places, is civil unrest due to uncertainty and challenging legislative landscapes. And they call this a medium risk in the short term. So that was very interesting. And then they talk about how, though they don't control most of their buildings, and elsewhere they talk about data centers, they need to influence their property owners towards greener practices. And this is over the medium and long term, but they also mark it as a medium risks and explain the costs. And the last example I'll give here is from a UK company called Motorpoint, kind of a car retailer, where they talk about a bunch of different things: increased taxation, how energy changes, how carbon tax might impact them, and how this risk changes over time. So it looks like it would be low according to them in the medium and the long term, but medium in the high term, which means they just need to evolve their business. Further down in this report, if I can find it quickly, they also talk about how they thought this was really interesting. There's a policy risk of legal changes deterring the need from private vehicle ownership. So the government is making some investments into or they're tracking how the government is making investments into alternatives to car ownership. So obviously relevant to Motorpoint, but then you can say, all right, so car ownership doesn't really impact my business if I'm a software company or a law firm or a Actually, there's one company on here where car ownership really does impact your business and the audience. So you might want to like think about these things. And all right, if policy, you can think about carbon taxes and carbon emissions disclosures, but what if laws related to this changes because of environmental regulation, because more trains are coming out and therefore fewer cars are on the road for you to service? So some interesting examples there. I'll touch really quickly on a cool thing we're doing at Beehive to help, and then we'll share the stage with Nico and to have a little discussion. But so this is Beehive. This is our software. We do a bunch of things. I won't go into all of it, but a few things you might find interesting is that there's this benchmarking tool. So if you found it valuable to look at how peers are reporting on policy risk, you can actually benchmark yourself against dozens of companies in here and say, hey, how are they talking about policy and legal examples? How is Atlassian, who's one of my peers perhaps, talking about transition risks and regulatory risk? And if you want even more context, you can just click on them and that opens up their specific report. So that could be a useful tool to saying, all right, how am I answering this question? And how does that compare to my peers? The second thing that we launched, and this is brand new, is a library of global legislation. Our customers have a lot of trouble keeping up with the thousands of ESG and climate and environmental and recycling and waste and climate disclosure and risk laws all over the world that impact them. And there's many, many, many more bills. And so we're building out a library that has all these climate risk regulations all over the world. You'll be able to mark what applies to you from a law perspective or a bill perspective, see that in one place to understand your total financial exposure, again, quantify this risk. You may decide to put this into a report, or you may just use this to justify internally what you're doing around your climate work. You might say, if you want to go measure emissions and your boss or your CFO says, why? And you say, I think it's the right thing to do, or I think there's laws coming down the pipe, that may not be enough. But if you come to them and you say, hey, we have a $500,000 penalty associated with noncompliance for these particular laws, and I am proposing solving that with $100,000, which creates a 5x return, well, now you're getting somewhere, and you can do the same thing for bills which are coming down the pipe. And now this is really cool. This is the last thing I'll share here, where, all right, so we can say we have thousands of laws in here. We can mark what's applicable to you. And so you as a client can stay on top of them, quantify them, understand them a bit. What is really difficult is reading through these documents and really understanding. So there's a nice AI layer here where the AI is trained on the legal language itself, as well as comments from credible sources about these laws. And so you can come in here and say, summarize this law. I picked SB 253 randomly, the California climate disclosure. So we have this law in 40 words or fewer. And you begin to use this as a tool to understand these laws, to be able to communicate up, to be able to come to your legal team. Oh my goodness, and the live demo doesn't work. Don't you love that? Let's refresh and see what happens. Let's try this one here. Summarize this law in 40 words or fewer. I swear this was working minutes ago. Let's see how it goes. And so you can use this kind of work to, there we go. So nice. We like it when it works. I just needed a refresh. And you can say summarize it using 4 bullet points. And you can use this to train yourself to really understand these laws so that when you go to your lawyers, internal or external, my gosh, one more time. Well, this works well mostly. Let's try it again. We'll do a quick refresh, summarize this law using 4 bullet points. This is actually a new feature we released this morning. So yeah, that's why there's a little asterisk that it is in beta. There we go. All right, so it works with a refresh. So you can use this to train yourself, to teach yourself about the law, to come to your legal team prepared with some knowledge, prepared with some questions. And I think this is just to share a little bit of the roadmap going in some cool directions. So first of all, we need the AI to work a little bit better. So that's direction number 1. Second thing that we can do is automatically declare using AI which laws we think matter to you. So, for example, if you have a Dutch subsidiary and we know that about you because maybe your list of subsidiaries has been uploaded here, we can tell you, hey, there's this Dutch law you never would have heard of that requires you to do this. So there's a way of kind of informing you about these issues. The next thing you can do is begin to do some projections work. So right now in here, again, let's see how this works live. You might say, I only have 900 million in revenue and I'm a low emissions software company. Do I need to comply? This should come back and tell you no. But if you begin to say, all right, show me all the laws that for a $900 million company require me to measure carbon emissions, that can give you a little bit of that context. So this can give you a little bit of context here about what you're doing and how you're doing it. So just a few cool ways in which Beehive might help you do this kind of work. So, and next time we show this, all the AI will work properly. I hope everyone enjoyed that. Let's promote Nico here to a panelist. Nico, I think you just got a little notification, I hope. We'll see what happens if that works. And so I'm going to introduce Nico Van Alstein. There you go. Nico is a partner at a law firm called Shepherd Mullen. He's been there for many years. He also runs their ESG and sustainability team. And so very, very lucky to have him here to answer a few questions. Nico, you all set up? You can hear us? We're all good?
Yes, can you hear me all right?
Beautiful. Looking good, sounding good. Thank you very much. Perfect. Well, Nico, very quickly, I don't want to get into too much of your background. I want to just start off by saying maybe the first question, how has climate disclosure changed over the last 5 years? Where were we a few years ago, and how would you describe where we are now?
Well, things have been moving very fast. Where we were a few years ago is that really only the most forward-thinking companies were doing it at all because it was entirely voluntary. And those voluntary efforts were picking up and gathering steam. I mean, I'm in New York for Climate Week every year, and there were more and more panels and sessions about that. So it was increasingly going on. But nonetheless, it was all entirely voluntary, and so there wasn't the same degree of emphasis or need for people to think about it. But that has changed. That changed really with the SEC's proposed climate disclosure rule, um, and that garnered. I mean, I think there are 50,000 comments on the proposed rule. I mean, it got a huge amount of attention. And that then followed an elaborate course over multiple years of comments, revisions, changes. It was finally formally adopted last year. Was immediately the subject of, I think, 8 different lawsuits, which were then consolidated in front of the Eighth Circuit Court of Appeals. And of course, now that's it's it's not going to happen. I don't think the court will even get to it. It's going to be withdrawn by the SEC, and so that's dead. But the other driver, and this also was first announced at Climate Week by Governor Newsom in 2023, was California's adoption of SB 253 and SB 261, which is, as you know well, the SEC rule covered both GHG disclosures and climate financial risk. The California law is divided into 2 different laws. SB 253 are your GHG disclosures, and 261 are the climate financial risk requirements. That was adopted in 2023. You'd think that that would be the end of it. No, 2024 was a year of a lot of drama and a lot of back and forth and tensions, fighting in the legislature. The governor and the Air Resources Board, which is in charge of overseeing the program, sought changes in it, most notably the removal of the requirement of the disclosure of Scope 3 emissions starting in 2027. In the end, and the initial shot across the bow of the legislature was that the governor refused to include any funding for implementation of the laws in the proposed budget. But Senator Scott Wiener, who was the author of SB 253, then became the chair of the Senate Budget Committee, and things started to change. So ultimately, very little was changed. SB 219 was adopted last year, and all it did, really, there were a few minor changes, but really all it did was to kick out the implementation deadline for SB 253 by 6 months, from January 1 of this year to July 1 of this year. So that has garnered that law because it applies, as you noted earlier, to both public and private companies. The SEC only applied to public companies. With revenues over $1 billion, 500 million for SB 261 in California, that are doing business in California, I should say, then they are caught up. And with California now the fifth, and some people say the fourth largest economy in the world, well, of course, that draws a lot of attention. And so there's been a great deal of focus upon this. So yeah, that's where we find ourselves. I've been advising quite a few clients. I'll just say one more thing on this. Folks need to be aware that ARB, the California Air Resources Board, is now actively, they have staffed up, and they had budget for 38 hires to develop the regulations to implement these laws. And they are in the process of doing that. 2 things. In December, they issued 2 important releases. The first was that on December 5, they issued a guidance stating that they are going to exercise their enforcement discretion to basically say, because you're going to have to make GHG disclosures of Scope 1 and Scope 2 emissions in 2026 for 2025. So you got to measure your emissions in 2025, and guess what? We're in 2025, and we don't yet have the rules. The agency has said, if you make a good faith attempt to do so using a respected protocol, we're not going to hold you to the letter of the regulations, which they haven't seen yet. So basically, the guidance is do your best while you can for 2025, gathering that data, and they're not going to slap your wrist for the first time out if it doesn't fully comply with the requirements of the regulations, which are in the process of being written. So that's point one.
What? Go
Sorry.
ahead. 22.
Well, the other is that on December 12 or December 16 rather, they issued a set of questions to help them prepare their regulations to implement the laws. And we can talk about those more. The deadline for responding to the questions was extended to March 21, be in light of the LA fires. So it's an opportunity for folks to have input. The ARB, I've been working with ARB on climate matters for what, well, since AB 32 was adopted in 2006. And so I'm there a lot. I'm very involved with the process and know the folks at the leadership there pretty well. Um, I will say this, the ARB has a very strong commitment to a robust stakeholder involvement. I mean, they're really, they do listen. You can have input. I mean, the very fact that they're putting this out for questions, seeking that input, they likely will have a couple of stakeholder in-person sessions. Well, now a lot of them are via Zoom because of the pandemic, but there will be those kinds of opportunities to be heard. They will probably float a white paper or a draft before formally promulgating it. Once it's into the formal notice and comment process, it's frankly a lot harder to get changes made. They can be, but it's harder. But in this initial period, essentially now, you can really have you can be heard. You can have some influence. So I'll stop there, but happy to talk about it.
Yeah, that's very helpful. I want to start off with a question of interoperability. Many companies who hit these thresholds of 500 million or a billion and are focused on California, many of them also do business in the EU. And so my first question of that is the EU has CSRD and potential changes through it through something called the omnibus regulation. Even separately from that, the UK has had laws, like I mentioned, around carbon emissions disclosure or climate risk reporting for years now. There are laws on the books that have been followed for years, not something contested. For your clients who are still, and we'll talk a lot about how the current federal administration might be pushing on California one way or another, but for your clients who are still like, well, California hasn't yet released these rules and they might be pushed back and there might not even be a fine. And do I really care? How are they thinking about the maybe the strength or the legitimacy or the effectiveness of a California rule as it ties to the EU? Which one do they respect more than the other? Which one do they follow? How do they keep tabs on which one they should be focused on more?
And it's a quandary. It's a real quandary, and every client is different depending upon where their main activities are. We're advising a client now. It's an American company, but they have a significant subsidiary based in France that operates in the EU. They are large enough that they fall under the CSRD, and we are helping them with trying to determine what their reporting obligations are. And as you noted earlier, with reference to the Dutch law, that's true in most of the EU countries. We're finding that in France, that there's a lot of, it's not just, the CSRD guidance. There are additional or different requirements in virtually every one of the major EU countries. So unfortunately, once you're there, once you cross that threshold, and the threshold's a little bit complicated, but if you're big enough, including a non-EU company with activities and revenues in the EU, you're affected, you're brought in if you're big enough. Again, if you're on the border, then you want to do borderline, you really do want to study the criteria because they're a little bit nuanced. We can talk about that more if you'd like. But at any rate, if you're there, you've got a headache. Bottom line, there's a lot of details you're going to have to look at, and which takes priority will probably depend on where you are most active, where most of your business activities are. But to circle back to your other part of the question, what about California? Um, my advice to folks is get ready. Yes, you hinted at it, the federal government might try something, but I don't think they're going to be able to do anything here to be able to quash California's laws. And California, they are going forward. I mean, they've got the staff, they've got the budget, they've got the legal requirements to issue these regulations. Could they get kicked out even farther? Yes, but really, the laws are going to be on the books. You are going to have reporting obligations in 2026. Now, are they going to be super strict about enforcing them in 2026? Probably not, but they are going to be on the books, and there will be guidance.
Okay, so let's talk a little about that. They may not enforce them for a year. You and I were at an event with Senator Scott Wiener, who was one of the lead authors of this law, and he talked about how they can't not do that. Like the law says enforce them, and
Right.
they're saying we're not going to enforce them. So maybe there's contention
No,
there.
no,
But
they're
even
saying
if
they're
they
going to
did,
exercise their discretion to enforce
okay,
it with understanding, provided you have made a good faith effort to provide disclosures. So you look at the GHG protocol. I mean, essentially, that's what the guidance in the statute says.
follow that, yeah, or
All of
follow the
that.
five TCFD rules and do what that
Right.
says to the best of your ability, and don't be
Exactly.
unreasonable.
Exactly.
Yeah.
Then that is, well, does the ARB have an obligation to enforce? Yes. Are they, not every speeder on the highway is caught, right, and ticketed. I mean, there's a certain amount of discretion that
Yeah.
goes.
That's actually a good metaphor for my question, which even if you are ticketed, the ticket for carbon emissions is high. It's $500,000 for SB 253. For SB 261, the fine is $50,000 for noncompliance. My question is the following: $50,000 for many companies is a parking ticket, and oftentimes can be less, not always, but can be less than the cost of compliance. I know your advice is never to not follow the law, but I have heard from some companies who say, I've got a lot going on right now. I can't just follow every gosh darn California law that state decides to throw up there without giving the advice. Or know your advice is follow the law. But do you ever come across companies in these regulations or others who try to think about the trade-off of non-compliance and say, I got 1,000 priorities right now. The penalty here is $50,000. Maybe I wait a year because I just don't have the time, money aside to put into this. Do companies think like that at all?
I'm sure that they do. Yeah. When they do, they're usually not talking to me, because if they're talking to me, they're interested in complying. So my folks, I mean, and of course, my guidance is going to be to assist them with complying. And right now, to assist them with trying to shape the regulations before they
Hmm.
come out. That's where
Hmm.
the real action is. But to your
Hmm.
question, it becomes a risk analysis, becomes a risk mitigation strategy. I mean, because there's not only the stick of the fine potentially that facing, they're facing reputational risk.
Hmm.
And some companies, that are perhaps retail-oriented companies, are going to care more about that reputational risk. If you're a
Hmm.
back-end logistics company and you deal with five different mega shippers, and that's your total world, then maybe you don't care so much, because
Hmm.
your risk is good, because there's the risk of enforcement from the state, but there's also the risk of reputational risk and potentially even civil actions,
Hmm.
so
I
that's
imagine it also, if you are not complying with something, it is difficult for lobby in Sacramento for other laws. If
no,
you're
that's
out
for
of
sure.
compliance with certain laws, senators going to say, "Well, you didn't follow my other rules." Like, I'm not going to listen to you on to your perspective on these others.
Yes, yes.
Yeah. Um, how do you think? One of the things that I find interesting is that there is both an effort at the international level to consolidate a lot of laws,
Hmm.
and that's
Hmm.
where you see things like the TCFD gets adopted by the IFRS, or the ISSB guidance, which feels like a lot of letters, but at least they're trying to integrate things. And at the same time, there's lots of fragmentation. So some countries require just scope one and two, some countries require three, some countries or states require limited assurance or reasonable assurance at different dates and timelines. And I think there was a thought during the SEC climate disclosure bill era that, okay, this is another step towards unifying one global effort to say, here's what we want to see and simplifying that effort. Now, what you see with the federal government not taking the lead, you saw dozens of states say we're going to comply with the Paris Accord. Many states introduced their own climate disclosure bills, and New York and Colorado introduced new ones in the last couple of weeks. If you were to take a bet over the next 3 to 5 years, Do you see climate disclosure bills being more and more fragmented, where different jurisdictions are requiring 50 shades of gray here and minor tweaks in all of them? Or do you think we'll move back to saying, all right, as a world, let's just say these are the parameters and the sizes and the expectations?
Right now, I have to say my assessment would be, and this is obviously speculative, is that most of the efforts afoot now are pretty fragmented, and I expect that that will continue. I mean, that's the state of the world right now, right? I mean, it's countries going it alone. We're back into 19th century views of the world. The AI summit in France recently just, fell apart because the UK and the US wouldn't sign on. So there are and there will be significant and consistent efforts to try to develop consensus. And I think that there will be a fair degree of consensus. I mean, I mean, there is a certain minimum threshold that most of these share, scope 1 and 2 emissions reporting, for example, that's
Hmm.
pretty universal.
Hmm.
So there's going to be a certain bottom line threshold that will, I think, be pretty consistent across these. But unfortunately, you're going to see variation amongst all of them. And the SEC rule, even when it was put out there, there wasn't the hope was that you could say, "Hey, I've got my CSRD. I'll just file that with the SEC,"
Hmm.
and the SEC said, "Nope, you got to do it our way." So that's I expect that that will frankly continue, and you see that within the EU. You see that within the EU, with each country
Hmm.
adding its own
Different
reports.
countries.
Right,
Yeah,
each country adding its own bells and whistles to the CSRD. So,
it's a company's nightmare, but a lawyer's dream.
well,
You
yeah,
don't have to answer
yeah, I'll pass.
that. Um, I want to talk a little about the current U.S. federal government, and specifically ask, you sort of mentioned this a little bit about California. It seems like, as a non-lawyer observer, one of the efforts that the current US federal government is trying to make is to say there's laws around the country that are state-specific laws that we don't necessarily agree with and that we don't think are good for business or good for the community, and we are going to sue them and push them and try to change them. I saw a statistic that in the first Trump administration, California won about 70% of lawsuits that the Trump administration filed against it. I also saw that both before the election and now certainly during, Governor Newsom and Senator Scott Wiener in California put aside a lot of money to fight against any
25
lawsuits at the
million.
federal government. 25 million. I saw 50 million, so somebody maybe someone cut the budget. But that's kind of part of my question here is high level overview of how much influence the federal government can have over a state's ability to pass these sorts of laws, both California, where they already are passed and you're just waiting on the details, or places like New York, Washington, Illinois, Minnesota, Colorado, where there are bills and maybe they will, over the next couple of years, move towards law. Does the federal government have a ton of influence and it'll do whatever it wants? Does it have absolutely zero influence? And hey, states' rights, states do whatever they want, or does it fall somewhere in between?
It falls somewhere in between. And sorry, lawyers dream, lots of complexity and nuance. First, just a little bit of background. I was very much involved with one of those efforts during the first Trump administration. The Trump administration sued California, arguing that its cap and trade program, which is its greenhouse gas emissions trading program, that links with Quebec, is was unconstitutional under the compact clause of the U.S. Constitution, and also that it was an improper exercise of the state getting involved with foreign diplomacy. And I represented the International Emissions Trading Association, and we intervened on the side of ARB to uphold California's cap and trade program, and we were ultimately successful. It was a fascinating case because there's only been one compact that has ever been held to be unconstitutional under the Constitution, and that was the compact of the Confederacy, as in the Civil War. So it's a very the authorities that we were relying upon in that case dated from the some as old as the 18th century in the 1700s. So it was very interesting. But to the point of more that was a bit of an arcane attack on a state program because it was under the compact clause. But you have much more likely ways of doing it, which is, and there are two doctrines out there. One is the supremacy clause in the U.S. Constitution that says the federal government has regulated a field, so we've stepped in, for example, interstate commerce is regulated uh, by the federal government, or anything where the federal government has got standards, those are supreme. We see that being litigated all the time with the Clean Air Act. The Clean Air Act has requirements, right? But there's a provision in the Clean Air Act that was adopted when it was adopted in 1971, I believe. It said if California wants to do something more than what we, the federal government, are saying, they can get a waiver from EPA. And for years, for decades, those waivers were freely given. That's stopping. Obviously, the Trump CPA won't do that any longer. But that's an exception. It's an express exception to the supremacy clause that says if the federal government is regulating here, you states cannot do anything more. But of course, there are plenty of areas where the federal government does not regulate. And that brings up the related doctrine of the dormant commerce clause. And that says if a state is regulating in a way that regulates products outside its borders, then that violates the doctrine of the dormant commerce clause. And this was recently addressed by the Supreme Court in the case of California's humane treatment of pigs law. And a lot of pork producers from outside the state sued, saying, "Hey, you're forcing us to have bigger pens for our pigs in Iowa than is legal in Iowa. That's regulating our activities in Iowa. You can't do that, California." It went up to the Supreme Court, U.S. Supreme Court, and the U.S. Supreme Court upheld California's law. So that, not saying the Dormant Commerce Clause is dead. It most certainly is not. There have been a number of very interesting cases under both the Supremacy Clause and the Dormant Commerce Clause doctrine in the last 10 years around issues of climate and clean energy, especially. So that's going to be, I fully expect that there will be some challenges by the federal government or by other actors serving the interests of the federal government, certain red states, for example, that they may very well bring such litigation. All of which, now to come back to the question, are California's climate disclosure laws therefore vulnerable to those kinds of attacks? I don't think so. I mean, if you think about it, I mean, disclosure requirements, it's not, that's not a field that's really been occupied by the state. I mean, other than the SEC. But as the California law makes clear, there's a lot of room for other kinds of disclosure requirements. And these aren't new. There's all kinds of disclosure requirements out there, right? I mean, you file with the Secretary of State to get a certification to operate a business in any state, and you've got disclosure requirements. So, it's not.
You have to disclose who owns what percentage of the company.
Right.
Different states might have different thresholds of 10% ownership or 20% ownership, so they can make a little flexibility there. So these are just similar types of disclosed relevant information at the state, or our investors will not
and the requirements are in that state, right? Yeah. So California, you want to do business in California, you got to meet those disclosure requirements, all kinds, including climate disclosure. So I think they're probably not very vulnerable to such a legal challenge, but that doesn't mean one won't be brought.
Yeah, that's very interesting. Just a reminder for folks, feel free to chime in on the Q&A or just directly in the chat with any questions. Nico, what conversations are you having most with your clients right now? Is it at the very beginning stages of like, just teach me what's going on, I just picked my head out of the water? Are most of your clients beginning to do this work and they're confirming that they're doing it the right way? Or maybe this should be a totally separate question, but I was just spent 3 days at Green Biz, and a lot of the conversation was around legal exposure to over communicating things and exposure to stakeholders who want to, or aggressive shareholders who want to attack you for being focused on issues that they don't think are financially material, like DEI issues, or over focus on ESG, to become the target of some federal lawsuits because you're talking about this too much. And for example, I know one company where their chief legal officer actually asked the team to take down their impact report from last year because they just talked a little too much about DEI there, and they just don't need a target on their back, and let's see what happens.
So if those are the three stages, where are most of your clients right now? Are they like, what the heck is going on? Are they saying, are we good enough and just double check my homework here? Or are they late stage and saying, help me on like pull back or respond or figure out my exposure from all this work I've done over the last few years?
I hate to say it, but it's all the above. I would say most of my clients are in the, hey, does this apply to me? And do I have to? Do I have to? That's the initial step. And I did want to mention the very first question in ARB set of questions promulgated in December 16 was, how should we define doing business in California?
Hmm.
I mean, that's the threshold question for a lot of companies. If you have one little store out there, are you doing business in California? If your work is on the internet, and accessible by someone in California, are you doing business in California? I know the Senator Scott Wiener's view is yes to both, but we'll see what ARB comes up with. There's plenty of room for nuance for
Hmm.
small subsidiaries and the like. So that's keep an eye on that. But that's the first question that a lot of our clients have is like, hey, does this really apply to me? I've only got limited operations in California. Um, and most right now, the prudent answer is yes, but we'll see, and hence the importance of these ongoing questions. But and then we do have clients like the client that we're assisting, that's trying to comply both with the CSRD in different countries in the EU and with the ST guidance, what the TCFT have been rolled into here in the US, the ISSB voluntary requirements, because they're pretty sophisticated. They have staff in house that are doing this, as a number of companies do, and so we're assisting them more with legal details. So there are those kinds of folks, and then yes, hanging over all of this, a year ago, the big concern was greenwashing lawsuits, and there have been a lot of those. Now, people, you're seeing a lot of green hushing going on. Folks, as you say, taking down a lot of these things, not buying offsets and talking about buying offsets and the like. Um, and with Pam Bondi has made clear that the new U.S. Attorney General, that she and a number of the red states are going to go after companies for their ESG and DEI practices. I think that that's mostly politics. It's mostly talk, and there might be a couple of token lawsuits. I don't think it's a major concern, but sure, folks are, you have to assess your environment. You're going to get hit from both sides right now. Unfortunately, that's the reality. You have the potential for that.
That does seem to be the case where on the one hand, you say too much and you'll be attacked by one group of people. On the other hand, if you say not enough, maybe your employees or certain customers are going to have problems with that because certain companies like Salesforce or Microsoft that have taken strong climate leadership positions and require the same of their suppliers, they don't seem to be changing. And people like Mark Benioff are getting louder and louder about their climate commitments and the requirements of their company, of their clients, to do this kind of work. So that is changing. One last question for you, Nico, and this has been very helpful, so I really appreciate it. But sort of parting advice to a company who's sort of in the thick of it. And they're saying, yeah, maybe we measured emissions a couple times, and maybe we have bought some offsets, and we got some little basic ESG report. What are the main things that they should be looking out for? How would you guide call it their general counsel or somebody who reports to the general counsel to think about their responsibility over the short term, the next year or two, to comply with these laws, to take a stance where they believe or against what they don't believe? What kind of advice would you give?
Basic advice: A, get involved now in California if you can, and B, make a good faith effort and be clear. I mean, so if you make a good faith effort to comply with whatever protocol you select, right now, because we don't have regulations in California, but even if you're doing sustainability reporting, which California law does not require, if you're going to do that, um, use a respected protocol and back it up. I mean, I've reviewed draft disclosure reports by companies, and they're talking about doing things, and they're not doing it. It's like no, you better be doing it,
Hmm.
because that's where you become vulnerable to greenwashing lawsuits. This isn't just stick the PR people on it and let them come up with some nice sounding words. Yeah, we have a net zero goal in 2026. We're going to be net zero. And you're not taking any actual measures to get there, well, that's not credible. That opens you up. So, pretty straightforward. Use good guidance and be responsible and honest.
Yeah, I heard a line this week at Green Biz where somebody said um, a couple years ago, legal was the final check on the report. They do all this work, marketing writes it, sustainability works on it, and hey, legal, this good? Yeah, this good. Now, legal is like there on the very first draft where you go, hey, legal team, what do we think? What are the issues? What are the problems? Legal gives you guidance well before you're at publishing. I think bringing in legal earlier now, while challenging it you might not be able to say as much. I think it's actually going to bring a lot of required and necessary rigor to the sustainability work that we're going to try to do. A lot less fluff, a lot more real numbers and honesty. So, Nico, I appreciate your time. Thank you very, very much. Thank you all for joining. Next week, same time, Thursday, 2 p.m., we are going to be actually interviewing my co-founder, our chief data science officer, about how climate models get made. So if you want to understand how one predicts where wildfires or floods might occur next, that'll be really fun. But thank you, everybody, very, very much. And thank you, Nico.
Thank you.